Hello, good afternoon. Thank you all for joining us today. I'm Carrie Pleasance, the Executive Director of the Fair Housing Center and a member of the Housing and Community Development Forum Series Planning Committee. On behalf of my fellow committee members and the presenting organizations, Home Repair Resource Center, the Fair Housing Center for Rights and Research, and the Greater Cleveland Reinvestment Coalition, thank you for joining us. Today's forum will explore source of income protections for renters who rely on housing vouchers and other lawful forms of non-wage income to secure housing. While source of income is not protected in Ohio under fair housing law, it is protected in a small number of local fair housing ordinances. Today's discussion will address how this uneven legal landscape affects housing access across the state for vulnerable groups and highlight the increasing number of municipalities adopting SOI protections. Additionally, the session will cover recent constitutional challenges to these protections and their legal implications. It's my pleasure to introduce our speakers for today's forum. Moderating today's discussion is Catherine Hollingsworth, Executive Director of Northeast Ohio Legal Aid. Catherine works to amplify community voices and accelerate positive change in the community through local legislative initiatives and other policy advocacy approaches. And today we'll first hear from Hazel Rumish, the Director of State and Local Policy for Ohio at Enterprise Community Partners. She advances policy solutions that expand access to affordable housing and strengthen renter protections across the state. Based in Cleveland, she works at the intersection of housing, equity, and system change, advocating on issues related to fair housing, federal housing policy, and statewide tax and housing policy. Following Hazel, we'll hear from Professor Heather Abraham, who directs the Civil Rights and Housing Clinic at the State University of New York at Buffalo School of Law, a litigation clinic dedicated to enforcing and advancing civil rights and government accountability with a particular emphasis on fair housing, employment discrimination, voting rights, and a range of housing-related assistance, including eviction defense in the Buffalo City Court. I will now turn it over to Hazel.
Thanks, Carrie, and good afternoon, everyone. As Carrie mentioned, my name is Hazel Rumish. I'm the Director of State and Local Policy for Enterprise Community Partners. If you are not familiar with Enterprise, we are a national nonprofit focused on affordable housing. I work in our Ohio market, really focusing on making sure that families have a safe, affordable place to call home. I am going to share my screen, so if you all just give me 1 second. So today we're focusing on source of income protections, and my portion is going to focus in particular on what the Ohio landscape looks like. We'll talk about what the protections mean for renters, who relies on these types of protections. We will look at the current landscape, why this legal patchwork matters, and how it affects access to housing, and what we can do to reduce discriminatory barriers and expand that housing choice. So what is source of income discrimination? Source of income discrimination is really focused on it's about the form of payment. So a renter might have enough income to cover the rent, but they may still be denied housing because part of that income comes from either a housing voucher, Social Security benefits, disability benefits, child support benefits, veterans benefits, and other lawful forms of income. So it's really about the form of payment. It is generally a payment that is coming from income that is not related to employment, but it is a lawful form of income. And so this is different from screening for the ability, whether a tenant has the ability to pay, whether what is the tenant's rental history, or whether there has been some lease noncompliance. This is completely different from that screening process. It's really focused on when a landlord or a property manager or a housing provider is refusing to rent to someone because their income comes from some of the sources that I just mentioned, rather than whether they have the ability to pay. So in practice, what does this type of discrimination look like? Many housing denials happen at the earliest stage of the housing search. So a potential renter may never get to submit an application to a prospective landlord because the landlord says, we don't accept a Section 8 voucher, vouchers are not accepted, or no Section 8 right out of the gate in their advertising. A landlord also could require that income be from employment only. And if it's not income employment, then they might require that this tenant or prospective tenant pay a higher security deposit or additional fees because of the tenant's source of income. At the core, it's treating applicants for housing differently because their income is coming from non-wage income. But this type of discrimination can also be a little bit more subtle. It can be where a unit all of a sudden becomes unavailable, or the landlord stops responding, or the tenant is told, or prospective tenant renter is told that there are different requirements after they mention that their income is a non-wage income. These early stage refusals really reduce the universe of available units that are available to voucher holders, and it can really make it more stressful and diminish opportunities for families. So why should we, why does it matter? Why does source of income discrimination matter? Well, a housing choice voucher, or really any sort of rental assistance or benefit that a person is receiving, can be life-changing. We just talked about some of the different varying benefits, right? It could be a veteran, it could be somebody who's in disability, and those benefits that those folks receive are really life-changing in that they provide a level of stability that they might otherwise not have. But it's only as good as but it's only good if the renter can find a landlord that's willing to accept that level of income or that type of income. Specifically regarding the voucher program, as I mentioned, I'm based out of Ohio. Our office at Enterprises in Cleveland. So I just wanted to highlight how vouchers are being utilized in Cuyahoga County, and specifically in this in the Cleveland area. So the result of the way that vouchers are utilized, as you can see, they are concentrated in very specific parts of our county. And it limits where voucher holders, older adults, people with disabilities, and renters can live. And in particular, I just wanted to highlight this because families who need 3-bedroom units, for example, are really limited in the amount and where they can live. And you can see here from where vouchers are utilized that they are concentrated in lower income areas throughout the county. So what does the Ohio statewide landscape look like? Ohio does not currently provide statewide source of income protections. Federal fair housing law, which Professor Abraham will talk about a little bit, it protects against discrimination based on race, color, national origin, familial status, and various other protected classes. Ohio actually has some additional classes that are protected that are not included in the federal regulations, such as ancestry and military status, but source of income protections is not one of those. Now, I'll mention a couple of things that over the course and I'll just on the slide here, you can also see that there are other states like Illinois, Maryland, New York, and Virginia that do have statewide protections. But I'll mention that over the course of several years, at various different general assemblies, there has been legislation introduced at the state level in Ohio. This one that I have on the screen is one that came out of the 135th General Assembly, which was in 2324. This was House Bill 150. And this one would provide, it was a bill that was introduced that would provide protections from source of income discrimination, but it did not really have a lot of traction. It did not make it out of committee. And so what that means is that local ordinances are doing a lot of the work, and renters' rights really vary substantially depending on where they live and what municipality they're in. One other thing I want to mention regarding the statewide landscape is that we often get questions about preemption and whether there are any preemption laws in Ohio that bar source of income protections for renters. This is because in 2022, the General Assembly amended the Landlord-Tenant Act, which is codified in the revised code under Chapter 5321, and it was amended really specifically under House Bill 430. So this was back in 2022. Now, House Bill 430 is really a utility bill. Um, what it's focused on is rent control, which is defined as requiring below market rents for residential premises or controlling rental rates for residential premises in any manner. Now, this was something that was kind of slipped into House Bill 430, which is a utility bill, but source of income protection laws do not impact the amount of rent that a landlord can charge a tenant or attempt to control the rental rates for residential premises in any way. So preemption in this instance, while House Bill 430 does have a preemption related to rent control, it does not necessarily impact automatically source of income protections for at the state level. So again, this has left a lot of the patchwork in left up to the municipalities. So this is a list of jurisdictions that currently have source of income protections enacted and the dates that those were passed. These local laws generally prohibit discrimination against renters based on lawful sources of income, including the Housing Choice Voucher. Although the specific provisions really vary by jurisdictions, some of these ordinances may explicitly protect voucher holders. Some may define income. Some may have different enforcement mechanisms. It really just varies depending on where you are. One other thing I wanted to mention is that if you look at the dates that many of these ordinances were enacted, many of them were passed in the pandemic or post-pandemic era, where there was an infusion of federal funds available to stabilize renters and landlords and to protect landlords' investment in property. And that was something that had not happened before at the federal level and the magnitude that it happened during the pandemic. And so there was a lot of momentum to make sure that those funds were both available to tenants and a protected type of income, and also a way to stabilize landlords' investments in their neighborhoods. And as I mentioned, we are based out of Cuyahoga County, so I just wanted to highlight here. These are the 5 municipalities that have source of income protections in Cuyahoga County, and just wanted to put a screen out there for reference for folks. So again, the local ordinances vary in scope, exemptions, what the enforcement remedies are, and it's creating an uneven system of protections across the state. The definition of source of income really varies depending on where you are. So some of them do include housing vouchers, others are more broad and include all sources of income, like what I just mentioned, disability benefits, veterans, etc. Some ordinances exempt owner-occupied properties or small landlords, under a certain number of units, and others apply more broadly. Some prohibit discrimination right out of the gate, so landlords cannot advertise no Section 8 or that type of advertising, while others really are just focusing on refusing the rent. The enforcement mechanisms vary across the state. So some it's through local housing rates, others have a civil right of action. And then the remedies also vary across the board, from injunctive relief to attorney's fees to monetary damages. Now, even though there is a disparity across the state, that's not to say that these protections are not valuable, but the practical takeaway is that geography matters. So whether a voucher holder is protected depends on where they are searching for their housing. And protections may exist in one city, but not in a neighboring jurisdiction. And the inconsistency is one of the strongest arguments why a statewide legislation would be helpful in this case. So this patchwork approach is more than just a legal technicality. It shapes real housing opportunities as a family may be protected in one suburb, but can try to move across the street and that neighboring city might not have that protection. Voucher holders are spending a lot of time, or folks that are, that have income with these different varying benefits, spend a lot of time searching for units and calling landlords only to hear that then it's not accepted. Or service providers, folks who are on the ground helping folks find housing, might need to explain different rules for different municipalities. And it's really just very challenging, especially when we're in a tight rental market where units move very quickly. And so renters are really left with uneven protections, and it really reinforces segregation and limits access to opportunity. So when we're thinking about what are some of the things that should be included in a source of income protection law or ordinance or even a statewide, obviously the first one would be that it should be at the state level to reduce this patchwork approach that we have seen throughout communities. But that strong protections need to be clear enough that renters, landlords, and enforcement agencies know what is covered. The definition should explicitly include vouchers and all of the other different source of payments that we just talked about. So disability benefits, child support benefits, veterans benefits, rental assistance. It isn't just about vouchers. And so it really, a definition that of what source of income is protected should be broad and expansive to protect all of the different categories of people that are getting access to these benefits. It should really be explicit also in order to avoid ambiguity and make sure that it's implemented properly. It should focus on not just a denial, after somebody has applied, but really on the front end, the advertising that happens. So the no Section 8, all of that should be considered discrimination in order for the law to be strong. And it should limit what can be the different types of terms that tenants would be responsible for paying. So, we talked a little bit about the fact that sometimes landlords will require higher security deposits, or they'll require additional fees, or they'll have different terms depending on what your income is. And so all of that should be encompassed in an ordinance that considers that discrimination. Statewide protections obviously would create consistency across the state, but in the meantime, local governments can continue to lead by adopting and strengthening ordinances. Any policy design should include enforcement capacity, public education, and coordination with housing authorities who are really on the ground talking to both landlords and tenants about their opportunities. And I just wanted, before I wrap it up, I wanted to kind of talk about, there's been a lot of momentum in Ohio, and that's significant. There's 23 jurisdictions that are doing this work, but that current patchwork does leave many renters without clear protection. And so for advocates, policymakers, and practitioners, this work is both legal, but it's also practical. It's about adopting clear protections, enforcing them, and then educating to improve program administration and really continuing to focus on real housing choice for communities. And so with that sort of background on what is happening in Ohio, I'm going to hand it over to Catherine, who is going to do a very important poll for the folks that are seeking CLE credits. And then we'll hear from Professor Abraham about sort of what is going on in the constitutional challenges. So Catherine, I'm going to stop sharing and I'll hand it over to you.
Great. Thank you so much, Hazel. And I will invite my colleague Izzy to launch the first poll. We will have 3 polls total in today's session. So this is the first poll. We'll give it a couple more seconds. All right, Izzy, I think you can end it whenever you deem appropriate, and we can move on with our presentations. And I just want to encourage folks to put any questions that you have in the Q&A. We do have the chat limited just so that if you're having technical issues, you can reach out to the hosts on any technical issues. But for questions that you want the panelists to see and be able to respond to, if you'd put those in the Q&A, that would be great. And I think we can share the results. The correct answer was false. So Cleveland does not yet have a source of income protection for the city of Cleveland, although there certainly are municipalities around Cleveland that do have that protection. Okay, so I am going to invite Professor Abraham to come on video and start her presentation. And thank you again to Hazel for the first presentation, and look forward to hearing what Professor Abraham has to say. Thanks so much.
Thank you. I'm going to assume everyone can hear me. Please let me know if you cannot. So I am so grateful to be invited. Thank you for inviting me to this roundtable. It's such an important issue, and I've been thinking a lot about it, as I think this presentation will show. So admittedly, my presentation is a bit more dense because this is a legal CLE as well, but I will try to give a broad variety and explanation. But please bear with me, take some notes, and we'll have a good Q&A at the end. So I'm glad to answer any questions, especially if I use some legal jargon that is not clear to everyone. And if so, my apologies. So, where are we going to go? First, I'm going to give a quick disclaimer and then go into definitions and some impact. So, recovering a little bit of the ground with a little bit more detail than Hazel just did. Then I'm going to talk about the evolution of discrimination, as well as offer a national perspective on the legal landscape, and then spend quite a bit of time on these legal challenges that are now happening throughout the country regarding source of income laws at the state and local level. Then I'll do a short review of a couple of things regarding the Fourth Amendment, and we'll open it up to Q&A. There will be 2 polls during my session. So, because I'm a teacher, I like to begin with learning objectives. My hope, first and foremost, is that I build on your existing knowledge of source of income laws. You may have gained some new or initial knowledge from Hazel's presentation today, but I also imagine that many of you already work in spaces where you know quite a bit of this. And so I'm hoping to offer to deepen and broaden that perspective. I'm also hoping to offer a national context for the expansion of source of income laws at the state and local level and talk a little bit about federal law. Then describe the growing body of Fourth Amendment constitutional challenges to source of income laws. And finally, this is why I hope I can be most helpful here and why you're here, is to give you some practical strategies if you are in a position where these legal challenges are somehow affecting you. So that might be how to respond to them, including how to draft or amend local laws to avoid litigation. I don't think anything can be litigation proof, but you can take steps to make sure that you are complying with the Fourth Amendment. So that's especially true if you are a local government or an agency that administers vouchers. So, as a fair disclaimer, this is not legal advice. The following presentation is intended to help you understand recent legal developments based on my legal research. It's not intended as legal advice and should not be relied on as legal advice. And as a caution, as I'm sure you're experiencing, the legal landscape is changing very quickly. Many source of income cases are ongoing. They have argument coming up. Courts could issue decisions at any time. And many state and local laws are new, as evidenced by Hazel's list of the 23 in Ohio. And that local or state government, depending on where we are in the country, may not have issued any guidance to help interpret it. So there may not be any clear precedent. So again, this is not legal advice, but hopefully I can grow your knowledge and help you to operate within the law. So, what is fair housing? I always like to start with this fundamental question to make sure that we are using the same terms and we have a shared understanding. So, fair housing is the right to choose housing free from unlawful discrimination, which is defined by a protected class. So, Hazel identified those under federal law. There's 7 common ones, including race, color, religion, disability status, familial status, which means if you have children or are pregnant. And then there's affordable housing, which many people in our society use interchangeably. People all the time assume that fair housing means affordable housing when they talk to me. So affordable housing refers to income. It's housing that's reasonably priced within the financial means of people of average or low income. So that is a very, very general and broad definition, but most importantly are 3 points. One is that it varies by context. It's often very relative, such as a percentage of the area median income for the community at issue or the metropolitan area at issue. And a very common standard is one used by many government agencies, including HUD, which is 30% of a person's gross income before taxes, including the cost of utilities. So 30% of someone's gross income. So in summary, fair housing refers to discrimination-free and equal opportunity housing. Affordable housing it means affordable relative to someone's income. So why do I offer that? Not only do I want us to have a shared meeting, but I think those two areas intersect in when it comes to housing vouchers. And that's one reason I write about them so much and I think about them. I litigate about them. I try to triage cases that have sustainable subsidized vouchers or other government assistance when I defend people facing eviction. I want to make sure that they do not lose that support. And so housing vouchers both present have to do with affordability because people are getting assistance to pay their rent, but also fair housing because it is a protected class in many communities or is advocated to be a protected class because it makes such a difference in the ability to get discrimination-free housing. It's an important factor. So what is source of income discrimination? I know this is repetitive of what Hazel presented, but I know from teaching adult learners that this repetition can be very helpful. So just to go over it one more time and give some examples and its impact. Source of income discrimination is refusing to rent or treating differently a renter or prospective renter because of the source, not their ability to pay, not the amount of income, but their source of their income, such as housing vouchers or other government benefits. And I have a slide next that shows the impact, but at the most general level, it has a list of problematic and far-reaching implications. Exacerbating homelessness, undermining the housing programs that we pay for using our tax dollars, or that generous nonprofits or philanthropists pay for these supports, and there are already too few of them relative to the people who need them. So that is undermined. Plus, it increases and reinforces segregation by concentrating vouchers in the same, often low-income neighborhoods, similar to the map of the Cleveland metropolitan area that Hazel just presented. So I created this very simple chart to show the ripple effect of these consequences. If you go down to the bottom center circle, it says voucher discrimination. So let's assume that a landlord says, I don't accept vouchers. The reason is my unit won't pass inspection. I don't want the government checking it. I just want to go below the radar and I just want to rent this out. That's one fact pattern. So they don't accept vouchers. As a result, if one landlord, multiple landlords do this, renters may not be able to put their voucher into use in the very short timeline that they have to use that voucher to find a place to live, in which case they may lose it. And that undermines the voucher program effectiveness, makes it less effective, less likely to reach the families who have been selected for vouchers to begin with, which is inefficiency. There's more turnover, and we know that people moving or being evicted or not being able to use their vouchers is not good for the local economy, and it creates more turnover, which has all sorts of implications. I did my entire master's thesis on people who are living in homeless shelters and the psychological implications, particularly on children, of being homeless for just even one night. So I have a sense of what that is like for people, and losing a voucher can contribute to that. So that results in many things, one of which is the outermost circle, which is that housing segregation and concentrated poverty result from this, especially if people lose their voucher and they have to go to a very bad, low, like poor housing condition area or unit, or they are doubled up or have too many people in a unit as they stay with someone else that they know, and many other versions of that. So now that I think we have an understanding, a common understanding of the impact of source of income discrimination, I just want to reiterate some examples, including some that maybe Hazel didn't mention, although she mentioned many. So one is the most obvious, which is refusing to rent to someone because of their type of income, ranging very broadly depending on what's defined in the specific law. It could be vouchers, Social Security, disability benefits, other housing subsidies, like there's county rental assistance. We have that a lot through our clinic when people need emergency rental assistance to pay their rent. Those are all examples of sources of income. Next is charging extra fees or a higher deposit or a higher rent. I've had cases like that in litigation as well. And then misrepresentation. Landlords may not realize this, but thanks to testing, fair housing testing, the testers may catch this, either record this, or they may be able to show a pattern of misrepresentation. So if a landlord says that a unit is unavailable, but it actually is available, or is not showing as many units, showing fewer units to someone with a voucher or a certain source of income, that is a fairly strong case that there's source of income discrimination happening. Additionally, steering people with vouchers to different units or neighborhoods. This is true of other types of discrimination as well, race-based. I've had cases in which landlords have told people with children that they should move to certain neighborhoods that have more yards or certain units and not apartment buildings. But specifically source of income discrimination, steering people to units in certain parts of the building or certain buildings or certain neighborhoods is also a form of discrimination. Similarly, not providing equal access to facilities or amenities. Sometimes that happens where certain parts of a building or certain facilities are not for people who are on programs or who have, those vouchers or Section 8. Also, not maintaining subsidized units to the same standard. That is something that we also see happening. Here are some common examples from advertisements. Hazel had one on her screen as well. These are things I've found on the internet over time. Very often they'll say no Section 8 explicitly. So I want to also take a moment to make sure we can spot problematic language that isn't so obvious. The obvious being this previous slide where it talks about no programs, no Section 8. Maybe it'll say no vouchers. Also problematic is things that imply that the apartment is for some people and not others, especially if it involves the source of income. Some ads will say employment required or employment income, or maybe a little more subtly pay stubs required, sometimes very obviously working people only. I've seen that. And it's important, this is a tip, is to do not mention preferred classes in a way that suggests that other people are not or do not belong here. So apartment would be ideal for young professionals. I've seen that one, and that ended up in a rather large federal lawsuit. It was a pattern and suggested it was a building for doctors and a building for other professionals or graduate students. And ultimately, when someone would call, they would say that kids were not allowed in that building. And they had years of history of not having kids in any of their buildings. So why does this matter? It strongly suggests that some forms of income are preferred over others, like employment income, but not vouchers. So language in advertisements should be very broad, should say equal opportunity employment, equal opportunity housing, should say that that everyone is welcome to apply, and ideally would say all forms of source of income welcome. So we're going to pause here for a CLE poll.
Professor, you're good to keep going.
Thank you. So let's jump back in with the evolution of source of income discrimination. So I'm going to read this chart from the left column to the right column, starting with what it says first generation and then second generation and later iterations. So what you've heard a lot of from me and Hazel is the idea of an outright refusal or denial. This is blatant We don't accept Section 8 or no programs. That statement is what I would call direct evidence of, intent to discriminate. I would like evidence like that if I were trying to prove that someone intends to discriminate. That's someone who says, I don't want these programs, and it's made more obvious. This is a form of differential treatment. That is an outright refusal, or excuse me, those are denials or refusals, and then differential treatment would be things that also are somewhat easy to prove with the right evidence, including screening out vouchers. If somebody calls, maybe ignoring the call or emails or showing fewer units to them. There should be a bullet point there for showing fewer units, and then higher security deposits. So something we talked about, treating them differently, and some of the other examples I gave 2 slides ago. These remain fairly common and widespread, and even if they're not in writing, they might be said out loud over the phone. I have lots of people who have come to me who have experienced that here in the Buffalo area, and it's fairly easy to test and to prosecute. Now to the right column, second generation. This takes different forms. Sometimes it is and sometimes it's not discrimination, depending on how it is implemented. And that's why our Q&A, I think, will be very important, because I know people have sent questions about minimum income policies or minimum credit policies, which I'm glad to address. So second generation source of income discrimination may include certain minimum income policies or minimum credit scores, depending on how they are calculated and implemented. And I do think those will continue to be challenged in court. So they can be practices that cross over from being, can this person pay, to discriminating against someone who has a voucher or other subsidy. So be very careful. Then the point is, these sorts of policies are more subtle forms of differential treatment that are harder to detect. Okay, another one that I've heard is no third-party contracts. Let's talk about that during Q&A, but short version is that is a big red flag. And if someone says no third-party contracts, I would easily argue in court that that's a form of direct discrimination or different treatment, but also would have disparate impact, which means I could argue it under federal law as well, which I'm going to talk about in a moment. So that's a very dangerous area to say we won't take third-party contracts, because that is directly related to housing vouchers, but not to someone's employment income. So it would have a very different effect on a protected class. So these are increasingly common, these second generation forms. I see them all the time. Often the policies are not so explicit. They're more subtle forms that are harder to detect. So I should say are not explicit. Okay. Sometimes the policies are, so minimum income, minimum credit score, sometimes they are much more subtle. I want to credit my colleague Armin Rajan, who works at Housing Works in New York City, who wrote this article. It's very helpful if you have any interest in the precedent around these forms of discrimination. I'd strongly recommend checking it. So what is the legal landscape? Hazel did a very nice job of explaining that it's a patchwork of primarily state and local laws, and I'm going to go into more detail about those for a couple of slides. Federal law is more complicated. As Hazel mentioned, it is not currently a protected class under the Fair Housing Act. However, it is possible that a lawyer, an interested party in counsel could still sue based on someone's source of income if a policy, such as a minimum income policy, such as a we don't accept third-party contracts policy, has a disparate impact on someone because of some status, whether it is a single mom with kids, whether it is source of income or otherwise. There is the possibility of disparate impact claims. Many states, including New York, also recognize disparate impact claims under state law, so not just under the federal law. Several bills have been introduced in Congress to introduce source of protection. The one example is the one I cited here. And when you receive these slides, all of these links should work for you in the PDF, so you can click on those. Some federal programs also have protections. So even though it's not a protected class under the Fair Housing Act, there may still be certain policies. And I'd strongly encourage you to look at these pages in the bibliography of the Poverty and Race Research Action Council, Research Action Council, PRAC, which has this wonderful Appendix B that updates. It's currently updated till March of this year, updates which states and localities have protections, has a lot of research regarding source of income discrimination. It's one of the best resources we have nationally. And then regarding the legal landscape, it is increasingly expanded. There are at least 24 states that have some form and 150 counties or municipalities that have some form of source of income protection. The statewide laws, most recent adoption is Michigan in 2025, and I speak to audiences in Michigan pretty regularly as I am attorney licensed there as well. Illinois in 2023, and then a group of them in the preceding few years, including California, Colorado, Maryland, New York, Rhode Island, and Virginia. So altogether, one source has calculated where people live relative to these protected areas, and they would estimate about 60%, maybe even as many as 2/3 of all voucher holders, specifically housing choice vouchers, so Section 8 vouchers, are covered by a law protecting them from discrimination. So even though it's only a patchwork and Ohio doesn't have a statewide law yet, a lot of people are protected. That doesn't mean in reality that these laws are well enforced. So every law is a little bit different. And just to give you an example, a very common approach is that the law adds source of income to the list of protected classes, just like gender or race or religion. So source of income cannot be treated like favorably or disfavorably under the law. So it cannot be treated differently. So please note and be very cautious when you look at these. Even though I said 24 states, there are exceptions and limitations, including limited by court interpretation. So right now in Maine and Minnesota, and not all of them cover housing choice vouchers. So you have to look at the definition of source of income in each law. Some model examples include the New York law, if you want to look at how that defines it. That is in the New York executive law, beginning at section 290. I think 292 is the definitions. I think it's subsection 36 if you want to look up literally how New York defines it very expansively. I think it's a model. Here are some charts that show this rapid expansion by state and by local municipality. And it's starting back in about 1989, going into 1990, and then showing how there's been a particularly rapid increase more recently. And as Hazel said, many of these laws were adopted around the time of the pandemic or shortly after to address the crisis facing many tenants, many people looking for housing and secure housing. And so this is one example of perhaps the most rapid expansion of any fair housing protection that I know of. Here's a map that was updated through 2024. So I added Michigan with the arrow. They adopted in 2025. And as indicated in the sort of medium blue shade, Ohio has the local laws only, including those 23 jurisdictions that Hazel had on her screen that are protecting this in Ohio. And if you really want to read more and get into the law about how it varies by state, I do really recommend this source by Robert Schwemm. Bob has written a lot on these issues. Professor Schwemm has written a lot on these issues. And one article is from 2020 that describes the source of income discrimination acts that exist throughout the country. Here's an example from the table of contents of all the things it covers that are very useful. So now I'd like to transition into talking about the legal challenges and that history. I want to begin by the history of two specific things I want to emphasize that have been argued in the past and sometimes are still argued. So the first one is that federal law does not allow these local laws, so it preempts it. So it basically says that these local laws can exist. It's an argument that doesn't come from the Fair Housing Act itself, because the Fair Housing Act is very clear that it is a floor, not a ceiling, and more protections can be added. It's actually from the housing choice voucher laws and regulations that people would argue it, with very few exceptions. And in one case in particular that's cited in the Robert Schwemm article from 2020, it is not a winning argument. Federal law has not been found hardly ever to preempt local laws. So while landlords are still pretty consistently raising this in litigation, I do not think it's a winning argument for a variety of reasons. And there's pretty good precedent suggesting consistently by other courts that it is not preempted. It's probably obvious based on the fact that there are 24 states, so half the states practically, and 150 jurisdictions that have adopted these. So if it really were preempted, you would think that there would be precedent out there at this point. And then a similar issue, but distinct, that I want to emphasize that Hazel did talk about is state preemption. So state legislatures can also pass laws that prohibit cities from having their own local protections. This has happened in a few places now, as Hazel presented, not Ohio. That's a separate rent prohibition or rent control issue. But in Texas, Kentucky, Missouri recently, and Kansas recently, those are examples of states that have said you cannot have local source of income protections. And those have been done often in response to localities passing these new laws. And so in response, the legislature has said, nope, not anymore, and it has mooted those local laws. And then there's also something called the administrative burden defense. The argument that landlords will often make is that it's just too costly or burdensome to comply. What that may mean is they know that their units aren't really up to code and wouldn't pass a basic voucher inspection. If that's the case, usually the voucher inspection is more or less similar to or the same as local building code. So it's likely that that building is not up to code, and that is the problem for the landlord. And the building should be up to code for someone for it to be human habitable. And so the administrative burden defense is presented frequently, or at least it has in the past. I don't see it in its current form as frequently, but some versions of it are pled in one way or another. It is not a winning landlord defense. It's really the only way that this would exist if it's explicitly in the text of the law, but I haven't seen a law with a carve out for landlord cost. So the second citation, also by Armin Rajan, is this attempted nullification in the citations. I'd strongly encourage you to look at that if you want to learn more about the history of people raising this administrative burden defense. And now I want to get into the heart of what we'll talk about for the rest of the time. I know that I'm going to get into the nitty-gritty a little bit, but I want to start big picture with the idea of these Fourth Amendment challenges. So the Fourth Amendment to the Constitution is what landlords are frequently, or property managers, property owners are frequently raising. And here's what the typical argument looks like. I'd encourage you to read over this and just kind of restate it to yourself if you're not familiar with these cases, so you can really understand the position that is being presented in courts across the country right now. The typical argument is that a local protection, state or local protection, source of income law, forces landlords to participate in a federal program, okay, the Housing Choice Voucher or Section 8 program, because the landlords can no longer refuse a voucher. It is true that these require landlords to accept the voucher on equal terms. They're not always required to accept a voucher if the person is not a valid tenant, they're not eligible, the voucher wouldn't cover the cost of this rent. Those sorts of reasons cannot pay. However, landlords are arguing that they are forced to accept a voucher. Okay, so that's the first piece. Second, in order to accept a voucher, which they say they are required to do under source of income laws, then they have to sign a housing assistance payment contract, the HAP contract. There are 3 specific provisions of the HAP contract that landlords typically object to, and those contemplate searches of either the rental premise or the records related. So it depends on what is asked. They're very vague in the sense that we don't know what records might be requested, but typically they would relate to determining if the rent is a fair amount, because the government is not going to pay an amount to a landlord if it is well beyond the value of this particular rental. So they want to check that before they place the voucher in that location. So the HAP contract, in the argument from landlords presenting these arguments, is that it compels an advance consent to searches because it describes and authorizes future access to the rental units and those documents I described related to the rent or the rental history. This, they would argue, is a non-consensual, warrantless search that violates the Fourth Amendment. So again, in places that have adopted source of income laws, landlords are arguing that this makes me sign a contract, and that contract talks about future searches, and those searches are a warrantless search under the Fourth Amendment, so they must be invalid and unconstitutional. Okay, so I'm going to actually just jump ahead and I want to go into what does the Fourth Amendment require and then go back. I think this makes more sense here. So the Fourth Amendment prohibits unreasonable searches and seizures. This is the federal constitution. It specifically anticipates unreasonable searches and seizures and says they are prohibited. For a search to be lawful, A warrant is typically required, that's the baseline, unless there is a legally recognized exception. One common and key exception is administrative searches. Those are searches that are typically routine health and safety inspections, like an annual elevator or fire alarm test. These are conducted every day across the United States. Very importantly, administrative searches are not criminal searches. They're not conducted to determine whether someone has committed a crime or will be used against them. They're conducted to simply determine the compliance with an existing building code. Okay, they are different than criminal. As such, the probable cause standard for whether the search is reasonable or not is much lower. It's much lower than criminal searches. And so I'm going to then go back. So that's just the preview. What does the Fourth Amendment require? Now I'm going to go into these challenges. So these challenges are very often raised, what we call the context of the procedural posture. Where in the case are these raised? Very often in the recent past, they have been raised as a defense once a landlord is accused by a fair housing center, by an individual plaintiff, by a local government, civil rights agency, sometimes by the federal government. They are told you have committed source of income discrimination based on this, based on our findings, our investigation. And then they'll raise the defense. Actually, these source of income laws are invalid. You cannot prosecute me under them because they violate the Fourth Amendment. And more recently, as we've seen in Ohio and University Heights, more property owners are filing affirmative cases challenging these newly passed laws. They are gaining momentum in courts across the country. Two courts have declared the relevant law unconstitutional. I can explain both of those in more detail during Q&A. One is in New York, and it's called the Commons West case, and it is on appeal. It's going from the intermediate court to the higher court, and I'll talk about that. And then the other was in Missouri, and that was the Jones case, and that's now moot, even though they were in negotiations to amend the local law, which is in Kansas City. But the state legislature last year preempted the Kansas City law. And so that case was at the preliminary injunction stage. So it wasn't actually on the merits, but it was analysis of whether they could succeed on the merits. And the court said, yes, they could. So that case, they did put a preliminary injunction, so stopping the law at that time. That was a few years ago. Altogether, there are 11 cases across the country. I think there may be 12 or 13, but I present 11 here today. And anecdotally speaking from my experience and others that I've talked to, landlords and their counsel are raising these in settlement discussions and other cases, and they're actively discussing it among landlord groups. Maybe some of you on this call are in these conversations, so you know about these challenges. Here is a list. Not that I will go over in detail during this presentation, but for you to have in your notes. And I do present this from the constitutionality of, so I say favorable, unfavorable, favorable, unfavorable, referring to whether or not the law was decided that it was valid or not. So favorable or unfavorable. So that's the case name, the jurisdiction, and the status of these key cases. If you see any errors, please let me know, but I've checked all of these and I'm following these cases. Several of them are still live, as I will talk about. I want to use the sort of precipice, the precipitating case of Commons West here in New York as an example of one of these cases, because I think it will bring to life what's happening, and then feel free to ask me questions about it. And as I say on the next slide, in full disclosure, I am one of the attorneys not on the case arguing in favor of the state, like the Attorney General has the case. However, I represent the fair housing centers in New York in an amicus brief, so a friend of the court brief, which I filed at the intermediate level, and I will file again next month at the highest court where this challenge is. So essentially in 2020, two prospective tenants in Ithaca, New York, fairly close to me in Buffalo, tried to use their vouchers, but the landlords refused to accept. So they reported them to authorities, and this got to the New York Attorney General, who decided to investigate under their special powers, did some initial depositions, and ultimately, after seeing a pattern of discrimination, refusal to accept vouchers, they sued these landlords under the New York State human rights law, which had a new protection that went into effect for source of income in 2019. So the landlords later on, they decided to raise a Fourth Amendment defense. So it didn't happen at the time of the inspection, which would have been the cleanest fact pattern, and it didn't happen right away in the answer and the pleading. It came quite a bit later. which is perhaps one of the reasons this litigation has gone on so long. But essentially, the trial court in Ithaca, Thompson County, ruled for the landlords, and the New York State Attorney General appealed to an intermediate court. That initial ruling already spurred more cases across the country, and it stirred up, I think, a lot of misunderstanding among landlords and certainly among other people about the validity of our state law. So I'll talk about that. The intermediate court recently also ruled for the landlords, and that was March of 2026. It was a pretty short opinion, and their ruling was that the New York state law is unconstitutional, at least with respect to Section 8 vouchers that have that HAP contract. The reasoning is similar to the argument I laid out before, that because the Section 8 program has a mandatory contract, the HAP contract, that authorizes specific inspections before the voucher and while it is in use, it violates the Fourth Amendment. However, the Attorney General has now appealed to the New York highest court, and the argument is scheduled for October 20th. So, as I mentioned before, I did file a brief in that case as full disclosure, arguing that it doesn't violate the Fourth Amendment, and I explain why. So, in my opinion, the intermediate court got the law wrong, and committed some of the common mistakes that unfortunately I think happen in this space for people who do not always understand the full nuances of the Fourth Amendment. So I do think that opinion was wrong. And so I'm looking forward to see what happens on appeal. And here are a couple of important limits, just because I want you to understand in case this happens in Ohio as well. These are New York specific, but just to show you the differences. This case, this ruling only applies to Section 8 vouchers. And I should say, because it's on appeal, the implications of that are stayed. They did not go into effect. It presents a major constitutional question. And so it hasn't actually affected New York law. It hasn't actually invalidated statewide. But it is probably very persuasive to lower courts right now. So only Section 8 vouchers are the ones at issue in this case, not any of the other types of vouchers or sources of income. So any housing programs, like many that are in New York City and certain other subsidies that don't have the HAP contract, none of those have been ruled to violate the Fourth Amendment. So landlords would still, even if this were in effect, if this ruling were in effect, they would still have to accept all of these other types of vouchers under that state law. It's only the HAP contract language. And the HAP contract is present in a few different programs. It is the Housing Choice Voucher and also project-based vouchers and HUD batch vouchers. Double check that, but that's my understanding. So it does not apply to any other protected class, just source of income. So race, religion, et cetera, those are all still valid protections under our law and would be if any lawsuit succeeded in Ohio as well. Assuming a similar ruling and argument, which is what I think is presented in the cases that I've seen filed in Ohio. So this means that landlords still and property managers and their agents must still accept all their forms of income as equal. As I mentioned, this is disability, Social Security, veterans benefits. None of those are affected by these Fourth Amendment cases. And I think some people misunderstand that. In our case, it only applies to the New York state law, and not any other city, not any other state. This ruling does not apply to Ohio. Those would require separate court decisions. And as I mentioned, it's not the final ruling. It's currently on appeal, and it's the intermediate ruling has been stayed for now. So if you want to go into the nitty-gritty and this interests you, I did write an article and the draft is available online at this link. I would encourage you to take a look at the synopsis, the abstract at the beginning if you want to learn more. And now with the time we have remaining, I'm just going to present the key legal arguments in a little more detail and then talk about the nuances of the Fourth Amendment, and then we'll back out, wrap up, and do a poll question. So let's evaluate what the key legal arguments are, or at least the reasons that I think these challenges fail. So in one way or another, all of these arguments have been presented in various briefs across the country. So first, very often the case is not ready for decision. So landlords have brought them too soon because they challenge a law as soon as the law has been passed, but not necessarily as it applies to them. And that's the second point as well. So a landlord has to be facing some sort of imminent injury. If you look at the case out of Lawrence, Kansas, not the one that was recently passed Tower, but the one before that, the landlords filed right away and they were dismissed for not having standing. So if it's either not ripe or there's no injury, sometimes we call that justiciability or no standing. It depends on the court's jurisdiction or jurisprudence in that area. But essentially, If a landlord has not been presented with someone who has a voucher and wants to use their voucher at that landlord's specific property and an inspection has been requested, up to that point, the landlord hasn't been presented with this issue, so it's really not ripe for a court to decide and the case should be dismissed. So that's the first issue that's wrong with a lot of these cases, and therefore shouldn't be, granted a ruling on the merits. The next one is many landlords just declare that these laws are facially unconstitutional, but my analysis is that they are not. These are as applied only. If you're not an attorney on this call and that's confusing to you, I'm glad to answer more during Q&A, but just importantly, there's a distinction there under the law as to how a court should handle that analysis and whether it needs to send the case back to the lower court to decide to do it as an as-applied challenge rather than declare a law unconstitutional just as a matter of law. So the third thing that I'll talk about some more is that I do believe in almost every case I've reviewed that there is a warrant related or an available form of review that satisfies the Fourth Amendment. That's in my following slides. So that on the merits tells me that these source of income protections actually are satisfying the constitutional requirements under the Fourth Amendment because they are not presenting a warrantless search without an opportunity to get a warrant. There are two other arguments that I am just going to very briefly summarize, but you can read more about in my article. One is that the HAP contract, so that contract that landlords, property owners object to, that language should be interpreted consistent with the Constitution. Many courts follow a common dogma, if you will, a common interpretation rule that says that we avoid constitutional questions or we interpret constitutional language consistent with the Constitution, which would be the Fourth Amendment here. And the HAP contract doesn't need to be read in a way that is unconstitutional. So that's a little bit in the weeds, but that's an argument that I think is very important. And finally, is it right to reach the ultimate conclusion that the law should be declared unconstitutional, or are there other remedies that can be sought, such as requiring the landlord to get a warrant or interpreting it as the HAP contract only presents the possibility of a search, but the actual consent to a search happens at the time that the specific search and its scope is known. So maybe it's a different analysis and there should be a different remedy. So there's some interesting questions there. Now that I've gone into the weeds, let's go back to the question of the Fourth Amendment. So I previewed this before, but what does the Fourth Amendment require? Again, it prohibits unreasonable searches and seizures and requires a warrant unless there's an exception. So what I'm going to talk about now is this idea of an administrative search, which I am confident, which is what Section 8 or Housing Choice Voucher searches are. These inspections are routine health and safety inspections, not intended to indict anyone in criminal proceedings, but only intended to make sure that there is, running heat, the working heat, running water, and certain things to make sure that the home is habitable and that it would pass that inspection under a low probable cause standard. So this is a little bit of detail as well, but again, I'm glad to try to clarify this during Q&A. If a search warrant, if an administrative search is valid, then a warrant isn't required. That's one of those exceptions I mentioned, as long as there is a legal process to obtain one. This is what the U.S. Supreme Court said in 2015 in a case called Los Angeles versus Patel. This involved a hotel owner who was presented with the choice to either turn over their records or essentially have consequences, which might have involved arrest by police officers who were immediately demanding records about the hotel's patrons. So in that case, the Supreme Court laid out there has to be something that allows the person to be searched to challenge the search if they want to. Sometimes this is generally referred to as either consent or warrant. They have a choice. If those choices are both available, it satisfies the Fourth Amendment, said the Supreme Court. So an example in the Section 8 context is that if a landlord is presented with a voucher, a landlord has a right to object to a warrantless search, and if they object, then the appropriate authority, I give the example of a city attorney's office, could ask court or maybe another neutral administrator, because the Supreme Court doesn't specify it has to be a court, to issue an administrative warrant. That if that warrant is issued, then the inspection can proceed, but under a lower probable cause standard. This means that the court, if the requester is asking for a warrant, they only need to prove to the court that the inspection is required under the Section 8 program and the scope aligns with that proposed search. So it's reasonable for the inspection. This is not the probable cause standard that there is reason to believe that crime has occurred, and this search will allow them to specifically get evidence that has a nexus with the crime. That's a much higher standard. That is not what this probable cause standard would be for a basic administrative warrant. And it's important to recognize that the Supreme Court, the precedent that I cited earlier, Patel, and the cases it builds on, especially a case called Camera, that precedent requires the availability of a pre-compliance review, so the ability to get to challenge the search or to get a warrant. But warrants aren't the only one. They're just one example of a way to comply with the requirement. So there may be other ways. In New York, we have a special procedure, something that challenges a government decision called an Article 78. And the Second Circuit, the federal Second Circuit, did declare that that is an example of pre-compliance review that would qualify. So we do have procedures in place. And so just to recap, a warrant isn't needed before conducting an inspection unless the landlord specifically objects. And if that person does, then the Supreme Court requires that a warrant process is available, not that the warrant be presented. Okay. And if it is available and could be sought, that is enough to satisfy the Fourth Amendment. I know that's a little bit confusing, but the Fourth Amendment essentially entitles a search person to consent or to challenge the search if they challenge it, a warrant is required. But the scheme is not unconstitutional just because they don't have a warrant on the front end for every search. I hope that's a little clearer. This is consistent with many routine administrative inspections for building code compliance across the country. And in theory, over time, landlords have generally stopped objecting to those day-to-day building code inspections, the elevator, the fire alarms, because they know that the government could go and get a warrant and force that inspection. So why make them do that? Right. So essentially, landlords have come to learn that this is just a part of the government's effort to make sure that it's complying with basic requirements. In the Section 8 context, ideally, every city has or will have a procedure in place to easily obtain an administrative warrant if one is needed. Most cities, if not all, already do have a process in place, but it could be clearer, which is what I want to talk about. And I also do want to note that I would argue that this entire area of law, the Fourth Amendment challenges to Section 8, could go away if HUD just changed the language of the HAP contract. We can speculate as to whether HUD is interested in doing that or in the current context would do that. But these cases largely hinge on the HAP contract language. 3 provisions. HUD could either amend the form to change those sections, or it could add some language clarifying that the contract should be interpreted consistent with the US Constitution. It's not intended to violate the Fourth Amendment. So HUD does have options to change that and create a new form that could arguably completely eliminate the need for these cases at all. And it also could amend its regulations regarding inspection requirements in some ways. I also, before I get into some practical ways to approach this, want to flag one more issue, which is that even though these are not HAP contract or Section 8 laws, I would ask yourself, does your city have a general rental inspection law for code compliance? Are landlords required to register for it or get some sort of certificate? That's true in many cities. That does not present the HAP contract issue, but they still have to comply with the Fourth Amendment, and most cities have pretty clear procedures to do that. But sometimes landlords will see things that make it very difficult for them to get the certificate or require them to pay something and do an inspection in a certain order that they want to challenge. So I've included on this slide cases with examples that show what is sufficient under the Fourth Amendment to survive constitutional scrutiny. We have 3 cases here. 2 of them are from New York. One is recently from the Eastern District of Michigan, so Flint. And I'd encourage you to look at those if you want to make sure that your local inspection laws are compliant. So here's where I want to wrap up. I'm going to ask you, what should you watch for and offer some next steps? So I would encourage everyone to note and document when landlords are refusing inspections under the Fourth Amendment. And please, if you see that, notify the Fair Housing Center for Rights and Research, and they're eager to know that this is happening and where, because it is a part of a larger effort to be aware of this development. Because it really, as Hazel and I both discussed, really can undermine the operation of the housing programs. Second, if you're a local government or a city law department, or perhaps you're an attorney who's been retained or might be retained by a city to look at this, I would strongly encourage you to strengthen or clarify your local administrative warrant procedures, including noting the civil aspect that it's not a criminal, it's an administrative warrant procedure under that lower probable cause standard, and any specifics about how you go and do that before a local court. There's a question as to whether housing, the PHAs could actually have their own neutral administrator who issues these. I have not done enough research yet to speak to that, but I would encourage legal, like law departments and retained counsel, to look into that process relative to the Patel case from the Supreme Court in 2015. So strengthen or clarify those procedures in case they are challenged and can be presented in a brief saying, we can get an administrative warrant if needed. So this source of income law is clearly constitutional under the Fourth Amendment. You might add a provision to your existing source of income law, or if you are passing one in the future, you might draft a provision in that says that the law is intended to be interpreted in a manner that does not violate the Fourth Amendment and should be interpreted consistent with state and federal constitutions. So something that offers a roadmap or an intention in the law. I would also encourage you to defend your source of income laws if you do have them. Sometimes people will back away from them and question whether they should have them. They're incredibly important, and just because they're being challenged isn't a reason to not defend them. I know that it costs resources, but I would strongly encourage local governments to find a way to defend them, and these should prevail ultimately if they're drafted well. You can also issue administrative guidance on what your law means, which is what New York City and New York State have done, among others. And you can contact me, and I'm glad to talk to you particularly if you're looking at it from an attorney perspective and you want me to put you in touch with others who are working on this and think through some issues and where to look for the answers. Finally, if you are a public housing agency, if you are a voucher administrator, I would encourage you to adopt a specific policy that states that the warrant procedure is in place in case a landlord challenges your process. And I can give you an example that New York has used, and there's a caveat to it, but I can give you an example of a policy that the state has considered. And talk to your local governments about specific administrative warrant procedures, just similar to what I said on the prior slide about why it's important to have them. Also, if I mentioned, please contact me if you're a city law department, city government or law department or retained counsel if you're facing this issue. Glad to put you in touch with experts who are litigating this. Possibly if you need amici, we can talk about that. And then also just trying to draft more effective source of income laws. So if you want to learn more, these are some resources on the final slide. One thing I will highlight, and the reason I recommend my article if you are interested in it, is the screenshot below that walks through in a pretty clear way under the existing law, pre-tenancy inspections versus one where the tenant is already there. Are these a type of search under yes, why or why not? Do they, within the meaning of the law, do they constitute administrative searches? Are the Patel standards, are they met by this, and why, when? And so you can look at that, and I think it spells it out quite nicely. So with that, my contact information is here, and I'll see if we can put that in the chat because we are going to go to a poll question now before Q&A.
Give it a few more seconds. We've got 65% participating. All right. Common definition of affordable housing references costing less than 30% of a household gross income, including utilities. That was early in the presentation, so congrats for those who retained that from early in the presentation. Okay, well, thank you so much, Professor Abraham. Lots of information in that presentation. And thanks again to Hazel for the first presentation. I am gonna go to our Q&A. We had some really good questions coming in. And so I'll just start sort of going through these, and we had some questions that were submitted in advance, and there are some themes in the questions. So I'll ask a couple from the Q&A from the live Q&A, and then circle back to a couple from that had been submitted previously. So the first question asks about how discriminatory housing, discriminating against Section 8 or other vouchers overlaps with redlining. And we all love a good map, and they're very powerful tools. And so I'm curious, Professor Abraham, as you look at um, SOI discrimination nationally, if you see that overlap with the traditionally or historically redlined neighborhoods as well.
Thank you for the question. I really appreciate it. Certainly, there are patterns and overlap, and I wish I could spend a lot more time looking at a lot more maps to see more proof of it. But instead, I'll use an anecdote or example. We had a landlord who had a drop-down menu on the online application in Washington, D.C., which has had a source of income protection law for quite some time under its D.C. human rights law. And it was at the edge of an area that had historically been redlined, very clearly an area that was a dividing line, a fault line, if you will, racially in the city. And we argued in a lawsuit, a federal lawsuit we ended up bringing on behalf of the National Fair Housing Alliance, that that was really important because that source of income discrimination was essentially creating this wall, sort of part of this blocking the ability of someone to move from one side to another and have opportunity in an area that had maybe lower crime rates, access to transportation. It was closer to some key train station, bus station, et cetera, and certainly other opportunity, better schools, the sorts of things that we think about when we talk about segregation and opportunity. And so that is one of, I think, many examples I've seen where landlords are living in an area where there's really key opportunity. And if someone, using their voucher, whatever type of voucher they have, can move into that neighborhood, it can, as we know from a lot of great social science research, including the Ross Chetty research, that it can, over the course of a generation, really change someone's life outcomes, right? In terms of earning potential, ability to finish more schooling, get a better job. So there's a lot there, and it's very rich. So I really appreciate the question. More broadly, the reality is that we see a lot of impact of redlining, right? And today there is still a lot of modern day redlining happening in certain, especially because of the access to financial institutions or the lack thereof. So there's a lot there. Great question. Thank you.
Yeah, and Hazel, do you have anything to add from a Cleveland area, Cuyahoga County perspective?
Yeah, I mean, I think that there's obviously a correlation between the two. Areas that have traditionally been redlined is generally where the highest concentration of poverty exists. I did want to highlight a resource from the Fair Housing Center, and I'm not sure where to put it in the chat, Catherine. Do I send it to
Uh,
everyone?
yeah, it would if you just go into the once you're not talking, if you go into the chat, you can choose for everyone, and then everyone would see what you're putting in there.
Yeah, I just threw in there a report from the Fair Housing Center for Rights and Research on the state of fair housing in Northeast Ohio. That's always a really great resource when looking at sort of some of these issues, specifically around like redlining and sort of the concentration. So I just wanted to throw that in the chat.
Great, thank you. All right, another question, which I think is super interesting, is the interplay between uh, asking for accommodations and income. So the question asks, can a tenant request a reasonable accommodation for a landlord to accept an alternative source of income, like a disability benefit, for example, due to the tenant's inability to work?
So I'll begin by saying that's a really interesting question because I haven't sat down and done a legal analysis, and because this is not legal advice, I'm really hesitant to say yes or no for sure. But here are some things that I can say. So when someone has a disability and they request a reasonable accommodation, and just for a quick footnote for everyone to follow along, we've got reasonable modifications, which are physical changes to a building, and then we've got or rental unit, we've got reasonable accommodation. So changes to policies, practices to accommodate someone so they can fully and equally participate and use that space as their home, just like someone who doesn't have that disability. So very often emotional support animals, service animals, etc. So when it comes to asking someone to change a policy, asking them to accept a different form of income, when they legally don't have a source of income requirement, so they could discriminate against someone based on that disability, I would say first and foremost that I don't worry about that being source of income discrimination, that if they don't accept someone's disability income, it seems to me like very risky being disability related. Like they're not willing to accept that. Is that disability and discrimination itself? Right? Who needs a reasonable accommodation to accept that if it's at the heart that is potential disability discrimination? So that's the first thing I'd be concerned about. Could you ask for reasonable accommodation for anything? Yes, and then the landlord is required to go through an iterative process in which you discuss whether or not it would essentially change the nature of the service that the landlord's providing. Them accepting the same amount of money from a different source sounds pretty reasonable to me, just as a sort of an initial analysis. So those are the key things I would say. I will say that maybe a comparable fact pattern that a lot of advocates talk about is when somebody asks to pay their monthly rent, for example, on the 5th of the month instead of the 1st. And that as accommodation because their disability check comes on the 5th or it comes on the 4th or the 3rd, and it doesn't get fully deposited into their account and usable until the 5th, and they don't want to overdraw, they don't want a late fee every single month. So will the landlord accommodate that? That to me is a pretty reasonable accommodation that is typically granted by landlords, and if they didn't, could legally be challenged. So probably a smart idea to accept someone's disability income as rent.
Great. All right, shifting to you, Hazel. There's a question about the sort of um, the public housing authority's role in this process with the inspections. And I think a common concern from landlords is the amount of time it takes to go through the inspection process, and that may cause resistance to accepting vouchers as the form of income for, or as the form of payment for rent. And so just curious if, there is any discussion locally around that process and, from a local perspective, and then Professor Abraham, if there's anything from the national perspective as well, but ways in which that sort of inspection process can be expedited to lower the pain point, if you will, for a landlord who's trying to rent a property as quickly as possible.
Yeah, thanks, Catherine. So, in order, I mean, I think Professor Abraham mentioned this, right? In order for a landlord to go through and become a voucher landlord or a landlord that accepts vouchers, they have to go through an inspection process through the housing authority. That inspection process, may take some period of time depending on what the inspection reveals. There have been some creative programming around the country, looking at things like whether it's incentives for landlords, right? Like, or a fee to hold a unit while they undergo that inspection process in order to minimize some of the potential harm to the landlord, or perceived harm anyway to the landlord, for having to, go through that inspection process and the length of time that it takes to go through that process. There have also been some really cool projects that have come out of, there's one in particular in Cuyahoga County where there's a demonstration project where the lease up is very quick and there's a liaison for landlords. So there's a lot of really creative things that have been going on to try to test how to minimize that gap that landlords are experiencing. I'll also mention that there's a question in the chat, and this is related, so I'll just address it now, around Road to Housing and the bill that just came into law last week. And I'll send this over in the chat after I'm done, but there are some provisions in there around that if a unit receives financing through one of the federal programs and it's been inspected in the past 12 months, it would meet the requirement for like the HCVP program in particular. So there are some provisions in there that might be tweaking some of this. Now, this is a long road ahead. Obviously, this is a brand new bill, how it's going to be implemented, the rulemaking that needs to go into place in order for that to happen. Still a lot to be determined, but there are, I think, some things brewing that might be addressing some of this concern. And then the other thing I'll mention is that one of the needs that we've seen specifically in Cuyahoga is that there are no navigation services. So if a tenant needs to find housing and they're going up against like these advertisements that say no Section 8, there's really no service that will say, okay, well, this landlord will accept a voucher, or here's an opportunity for you to connect with the housing authority and this landlord. So that there's a serious gap in terms of like the services that are available for residents to try to connect with the housing that's available.
I would be glad to add just a little bit to that. So one place that we start out with students, law students who join my clinic, is we begin by saying reasonable people can disagree on a lot of these policies, right? You may take the position of maybe some of my students, either their parents are landlords or they've grown up, owning properties. Other people have themselves been renters or have lived in public housing or other subsidized housing, had vouchers growing up, all sorts of perspectives. I've had some students who are very skeptical about people who are landlords or have that connection, and vice versa. And so there are concerns, and if someone has one perspective, sometimes that will influence how they see policy. What I would say is that I am certainly very sympathetic to the idea that a landlord has purchased rental property to make a salary or make a monthly or otherwise rental income, and that it influences the bottom line, their ability to pay the mortgage on it, their ability to keep it up, controls the rent amount, those sorts of things. That is real. At the same time, it is a business decision as to how much the rent will be, et cetera. And there have always been regulations. And when a legislature passes this new protection, it's another form of regulation that changes the cost of doing business, of being a landlord. And so the reality is that now the legislature has built that into the cost. Do I want a local housing authority or voucher administrator to take 2, 3, 4 weeks of potential rent off of the landlord's plate because they are delaying? No. Do I want the advocate to move very quickly, or whoever is involved tell the tenant we need to get this moving forward? Who at the housing authority can get this inspection done right away? Like cooperating, hopefully, and opening up the property as soon as possible to inspection goes a long way, in my experience, very broadly with different jurisdictions. So I cannot speak like Hazel did to the local jurisdictions that you're dealing with. However, it is the cost of doing business ultimately, and that's what a new law and a new regulation is. And so at a certain point, that's just going to be something that landlords in the market need to adjust to.
Okay. I'm going to switch to sort of a theme that was in some of the questions that were submitted in advance of the presentations, and those were around sort of enforcement of SOI protections that are in place. So we saw both, I think, in Hazel and in Dr. Abraham's presentations that there are different enforcement mechanisms depending on how these laws are written. And so curious for to hear your take on maybe where enforcement has worked well, where there are enforcement challenges. Are there thoughts or suggestions around how to make the laws as enforceable as possible on the front end? And then also some questions that came up around for tenants around documentation of where there is an SOI protection and they think that that's not being followed, sort of tips for what a tenant should be looking out for, and documenting would also help answer some questions that had come in.
Hazel, I'm glad to start if you want. So this is a big question that I could probably do a presentation on for an hour, right? These are big things. And if you're thinking about adopting one and you want to incorporate better enforcement mechanisms, first look back to Hazel's slide on a good law, whether it's statewide or local. There's some great points in there. Second, have a private right of action. I did see someone's question beforehand asking about laws without a private right of action. Frankly, I've actually never seen one that didn't have a private right. I guess I have technically in one amendment in one municipality where they recently put all of the enforcement power in their local city government. And so that the city law department has that authority now. But I think generally speaking, it's always going to have some action by a private party, which is parallel to and reflects the original Fair Housing Act, should say, as amended in 1988, really. So the Fair Housing Act, as we understand it today, as well as almost every other state and local law. Like there's some enforcement mechanism outside of the government. But typically there are three paths through which something is enforced, right? So there is an administrative process. So that often is a complaint filed with a local city, state, and sometimes federal HUD complaint that can go into a process before it ever goes to court. One is to file directly with court. Often a private entity can do that. And then there may be a different path is the government, the federal government filing, the state government, like an attorney general filing an action. So they're their own sort of separate from the other agencies, although there's referral between those agencies. So there's just different paths that can be filed, but by which a case can be enforced. But far more important is before anything ever gets to litigation, right? What's actually happening on the ground day to day to enforce these? My strongest belief is that we need to put more resources. It's a tough answer for local governments that are cash strapped to hear, but we need to have people on staff with the government and more support for fair housing centers, whether it's grants and better training and literally more staff. We know that the federal government has gutted a lot of these programs, including the FIP program to a great extent. So we don't have the same resources, but who is receiving the most complaints and documenting them, investigating them, and preparing these complaints or negotiating with landlords to change their practices? It's primarily these fair housing centers. In fact, I have data to suggest that 75% of all of the complaints, about 36,000 nationally in 2024, were fielded by private, essentially these fair housing organizations. Not private because they receive government funding very frequently, but these fair housing centers, like the Fair Housing Center that's hosting this call, they do the majority of the work. Second most, state and local governments and their civil rights offices or human rights offices, and the smallest number is HUD and the Department of Justice. So if you think about that local effort, we need as much resources, training, and frankly, we do really need landlord training like this and cooperation and accountability between different partners. So there needs to be trust there in order for landlords, I think, to feel that they can cooperate and open up their units in a fully equally basis.
Great. I'm gonna, oh, sorry, Hazel, do you have anything to add there?
I was just going to chime in on like a local perspective.
Yeah, great.
Last June, we did a roundtable of municipalities that had source of income protections enacted and asked them sort of like questions around what were your learnings, what were the challenges in passing those ordinances, and like how did those come to fruition? And we had some very specific questions around enforcement. And one of the things, to Professor Abraham's question around or his statement around resources, we heard from some of these municipalities that it was challenging to make the process efficient in terms of the enforcement. That tenant outreach was incredibly helpful. That they needed to better understand the interplay between their enforcement and the Ohio Civil Rights Commission, and sort of the interplay between that. And that city government sometimes felt in some of these municipalities too small to lead on the enforcement that they were required to do because of the resource question around staffing and how that challenging that is. And then the other thing we heard was that tenants a lot of times, when they face this discrimination, they might already be in crisis. And so they have a really hard time documenting what's happening and then following through because they're trying to deal with the crisis that they're in that moment. And then later, they don't necessarily worry about filing a complaint later on after they've settled into a new place. So all of those are like very real challenges that municipalities have to grapple with as they're like thinking about what do these ordinances look like. And one of the reasons why, right, whether it's a countywide ordinance or a statewide ordinance, would be a lot more beneficial than sort of this patchwork that we're doing, or even at the federal level. But that's just some of like the real life examples that we heard from like local municipalities that have these ordinances in place.
And Catherine, I would add, I recently asked one of my clients, how did you know that the landlord wasn't supposed to tell you that he doesn't accept vouchers? And she said, I saw it on Facebook. Our local Fair Housing Center had posted on Facebook. You never know how you're going to reach people. And so while it sounds very generic and sort of ungrounded when I say that we need more of these resources to have these public education campaigns, I know that they reach people when they're repetitive and they're put in places where people do access them. And this is someone who probably uses Facebook, but does not necessarily use Instagram or doesn't necessarily listen to the radio. And so this was one way that she was reached.
Great. So staying with that enforcement theme, there's a question in the Q&A that is specific to an ordinance, a local ordinance that has a criminal violation component. So there's a community in southeastern Ohio where there's an SOI protection in place, and that it's a minor misdemeanor offense if a landlord discriminates based on source of income. However, there's a law director that is refusing to enforce that ordinance. And so the question is, in the tenant community, what does one do if the law director is not enforcing a criminal or an ordinance with a criminal violation attached to it?
So that's pretty tricky. I'd have a lot of questions and want to hear more, but I think it's safe to say there's a question as to whether someone has responsibility or not. Is this within their prosecutorial discretion, or are they violating that? Are they essentially refusing to enforce a valid law on the books that violates a duty of theirs? So I want to know more about Ohio law, maybe that city code, and probably talk to an attorney locally to see if there's anything that can be done. Is this a misconduct violation by that attorney, right? There are specific misconduct rules that with respect to prosecutors. And so it might be worth looking at whether or not they are violating that by refusing. Is there a bigger pattern or practice by that municipality by failing to refuse that where they are violating some other law? So is that municipality, by way of that director's actions that have been documented in some way, a greater fair housing violation that should be challenged or reported to the state? Those are real questions.
Good questions. And one tool that is sometimes used in a situation where there's a government agency that is not doing what they're supposed to is a mandamus action. Have you seen anything like that, Professor Abraham, used to enforce these kinds of ordinances?
So I have not per se. In New York, we have something called Article 78 that I alluded to when talking about the Hudson Shore case, because that's a potential pre-compliance for review process that satisfies the Fourth Amendment. But we have had an organization here locally try to use that to enforce, after the city of Buffalo did not enforce its recently passed proactive rental inspection process. So that's on appeal right now to our intermediate appeal court. And so there's a question there that is probably parallel. So I don't know about that per se, but I think that sounds like a really interesting question. I also was going to mention the media, right? Taking this question to the media, is that going to get more attention, and possibly to the state attorney general? Although I know not every audience is friendly to the idea of requiring a local government to enforce a local law.
Thank you. Another question in the chat has to do with the interplay between source of income protections and fair market rate for renting. So I don't know, Hazel, if you can jump in on this one. But the question is, if there's an SOI ordinance in place, is it an option for a landlord to argue that the fair market rate for a property, to rent a property, is higher than what a voucher would cover? And is that a problem in a place where there's SOI protection?
Yeah, Professor Abraham might have some insight on this, but my initial instinct is that that is a pretext, or it can be seen as a pretext for not renting the unit to somebody who has a voucher.
Thank you for flagging that. I appreciate it. So there's very divergent fact patterns, one in which a place might have 4 bedrooms, a lot of square footage. It's newer remodel. It is worth $3,000, and a family wants to pay that because they have a large family, and that's going to be what it is. Whereas the voucher might only cover 1,200, for example. With family size, obviously the value goes up, and they're different amounts, but maybe it literally does not cover that. That in and of itself, that fact pattern would not suggest voucher discrimination, but that unit is more valuable than the voucher will cover. We do have some adjustments in policy, small area fair market rents. There are ways that voucher values are going up to try to account for the increased rent in many, if not all, communities in the United States. But if there is a pattern to suggest that you used to rent, so if someone's a landlord, used to rent it at a certain amount and you've sort of increased it in a way that's intended to go above the typical voucher amount to avoid that, or there's any language in your advertisement, or you're recorded by a fair housing tester saying something to suggest that you've increased it because you don't want people with vouchers in your property, that's a case, in my opinion, that suggests pretext and is highly litigatable. So that's not something that you want to do. Thank you.
Yeah, as a theme is certainly that these are fact-specific analyses, right? Depending on the facts that are being presented, and they can go either way depending on those facts. So this is a question that I thought was also very interesting, and I'm not sure I've seen answered yet, but um, the question is, would source of income protections require a landlord to accept a guarantor or cosigner? So what is the interplay between the concept of having a guarantor or cosigner on a lease and source of income protection?
Hazel, do you have an interest in starting this one, or do you want me to?
You can, that's fine.
Okay. So this is like one of the first questions I received. I don't want this to become legal advice. It's an issue that I'd want to sit down with and make sure that I'm sure on, because I think this gets debated sometimes and there might be specific facts that would change the outcome of the analysis. Here's what I can say. If you put that person in whatever cosigner through the same analysis to suggest that they can pay, right? You're allowed to ask, can this person pay? Do they have viable income? Does it seem to be consistent? Is there reason to believe that this person can pay the rent through the course of the 1 year lease or whatever the amount of time is? If so, it suggests to me that you should accept that income. I use the word suggest, right? Normatively, not necessarily legally, with that cosigner. I also know that in many jurisdictions that have source of income laws, student status, for example, matriculation status is one of the protected ones, because many landlords don't want to accept students who are getting parents, parents pay for their rent because students don't actually have consistent income, or they're getting tuition dollars and those are dispersed every 6 months per semester, for example. Some landlords don't want to deal with that. Others, they love working in the student market, and it produces potentially a lot of money. Depends on the model. One of the reasons those exist is because of that inconsistency. I do believe a landlord could do an analysis and say someone does not have the ability to pay, or that I don't trust that guarantor for this reason, or they, could fall off the scene. But if they're willing to pay, that would suggest the ability to pay. Again, I don't know for sure if you're required to accept a guarantor. Now, if that guarantor is someone related to them because of a disability status, or that person is actually their fiduciary through like a home health aide, this person maybe has a power of attorney and they're making the payment, I would be very cautious not to engage in discrimination based on disability and not accept that person's guarantor, because maybe that's their money or that's state money. So just be very careful about the facts. Beyond that, I just don't want to weigh in as to whether you absolutely do or don't have to accept it consistent with source of income law without doing more research.
Yeah, and Catherine, I'll just add that it really comes down to the specific individual ordinances and what is considered in terms of how they're drafted. So some ordinances might require that, source the income that's protected is from a third party, right? And what was the intent of that ordinance? Some of those ordinances, when they include that language, are really thinking about like a third party, as in a nonprofit potentially paying the rent on behalf of somebody else. So really thinking about like, what does the legislation say? How is it defined? And how has it been interpreted and applied are really important there too.
And Catherine, if I can add to that, then
Yeah.
I mentioned during the main part of my presentation that No third-party contracts as a blanket policy is a big red flag. I'm hearing of it a lot. Those cases are going to court. They're going to be litigated in some of the big jurisdictions. I know about the attorneys who have these in the administrative process right now in various states. That is a big red flag that landlords and property owners need to be very careful about. I would never suggest adopting a no third-party policy because it overlaps way too much with these protected sources of income, particularly government subsidies and other things that absolutely require a third-party contract, whereas income from an individual who owns, who has employment income and pays with their employment income doesn't have typically a third-party contract. So there's an alignment or potential correlation, or what I would say disparate impact against the person who receives that housing voucher or other subsidy. So we just want to be really careful with that piece. So it's one thing to talk about a cosigner or guarantor. It's another thing to talk about having a blanket policy not accepting third-party contracts. That is big red flag.
Great. We have heard both of you mention some of these landlord policies that say that a renter has to make 3 times the amount of the monthly rent in order to be considered for that property, to rent that property. And I know that both the presenters today have talked about how different different states and different municipalities have different requirements in their SOI protections. So the question that came in through the Q&A, it was whether have you all seen municipalities or other jurisdictions that have addressed that specific language? Because that seems to be language that is sort of in the rental market now that address that 3 times rent language in their ordinances or statutes.
Hazel, do you feel like starting? Okay. So a couple of thoughts. There's a lot to this. First and foremost, if you want to get into the weeds, look at Armen Marjan's article I mentioned. This is the one on different generations. So it's on one of the early slides with the first generation and second generation evolution of source of income. There's a lot in that article on cases in the recent years that have challenged these minimum income policies. And depending on how they're applied, they absolutely can be a source of income violation. It depends on how they're applied. You have to take into account that somebody has a voucher and that voucher has value in lieu of income, for example. So it is the equivalent of having some of that income that you might be required. So where do we think the 3 times comes from? My general thought is that it comes from that idea of the 30% affordable housing rule. It should be about 1/3 of someone's income or less, and that's a reasonable amount of cost for housing, including utilities. I think that's where it comes from. What many people don't know is that was a reasonableness standard that came out of approximately the Depression era, the New Deal era programs. And then during a time of recession in the 70s, Congress needed to change the policy. So they took it from something like 30 or 40% down to the actual, something like 40, 45% down to 30%. It wasn't actually that number. So they reduced it essentially to take cost off the books of the federal government. So there's a whole sort of interesting and precarious history as to what number actually marks affordability. So going back to one of my early slides, I would ask, what is affordability? It's affordability relative to the specific person's income. So let's just keep that in mind. So a minimum income requirement of 3 times isn't a great fit. That's very much a blanket, one-size-fits-all policy that isn't going to be a good fit for every renter. Some people have budgeted in a way that they can pay 50% of their income and they should really only have 2 times, and they're going to consistently make rent every month. Okay, so there's really interesting data on this that suggests that lots of people, including low-income people, will prioritize their rent and pay for that first. They can get other supports for groceries and things like that. So if I were a landlord, I would really second guess having a 3 times minimum policy. So that's my advocacy piece as to whether that's really necessary or not. Should you ask if someone can pay the rent? Absolutely, that's your right to do that. Versus the source, right? So that's really what minimum income policy comes down to. So that was a little bit of an aside. So 3 times the minimum income. If someone's rent is $1,000 a month, and they would have to show under that policy that they have $3,000 in income coming in order for that to essentially be affordable under that particular landlord or property management company's rules, right? In and of itself, that does not present a fact pattern that shows source of income discrimination per se, but I'd want to know why it's adopted and how it's calculated. If someone is not counting the value of their voucher toward that $3,000, that's a huge problem. But if someone has that income, a voucher plus additional income, and it meets $3,000 and that value that voucher can cover that $1,000 a month, then it does meet that policy. But I would also argue that you don't have to have that policy for someone to show that they're always going to make their rent. If you have a government guarantor paying it, basically the person is going to be able to pay their rent, right? Especially if it's 100% covered. And that's where I think the Armen Rajan article will explain that you get into hot water if someone has 100% of their rent covered and you're still saying that they don't qualify under your minimum income policy. That's dangerous territory because that might be some landlord might be challenged on that policy. So just be aware of it. So even though it's common, it's gray area. And then to the specific question, there are some municipalities that have adopted language. The one I know of is Ann Arbor. Ann Arbor, Michigan, if you look at the way it defines source of income, it explains how it needs to be calculated. There was also a version of the bill in the one that passed in Michigan statewide in 2025 that did not make it into the final version for any number of reasons that would have essentially said that you value the voucher at 3 times its value to count toward a minimum income. So I would still always follow that practice at least, but a voucher may very well cover all the rent and someone's needs, and they may have enough to pay rent every month. Thank you.
Great, thank you. We are coming close to the end of our time. These have been great questions. I just want to first say for folks that for questions we didn't get to, Professor Abraham has graciously agreed to field questions that are sort of from about legal interpretation and about what's going on in the legal landscape. So if there were a couple that were sort of specific to Fourth Amendment arguments that are happening in other contexts, and I would encourage the folks who have those questions to reach out to Professor Abraham to ask those. But I did want to open up the floor for Hazel and Professor Abraham just to leave us with any last thoughts or sort of if there's one takeaway from the presentations today that you want the audience to remember and take with them if you both share those brief thoughts, and then we will hand it over to Carrie for our closeout thoughts. And I'm sorry I didn't do this earlier. I was supposed to, but for folks who have asked, the presentation slides will all be circulated, and the recording will be circulated, and a survey will be circulated by email following the presentation. Not immediately. We'll have to get the recording downloaded, but then there will be an email that goes out with survey and the slides and the recording for people to refer back to after the presentation ends today. So I'll open the floor to whoever would like to close out thoughts.
Thanks, Catherine. I just wanted to say thanks to everyone for participating and being engaged in your questions before the webinar, but also during. If you have any questions about like what's going on in Ohio, what's going on locally, please reach out to me as well. We are happy to be a resource and are working on this issue, have been for a very long time, and hopeful that we'll get this over the finish line at some point in Ohio.
Thank you for the opportunity to just have a couple of closing thoughts. Thank you, everyone, for being here. I appreciate that you care about this issue. I know there are a lot of opinions. I know that it's highly controversial. I've read lots and lots of statements, blogs, seen lots of opinions on this, and certainly read a lot of briefs where there are very different legal opinions. So I've presented my analysis based on an honest and critical review of what the law says, but I'm also an advocate, and so I see the opportunity that source of income protections do present and how much they can touch lives. And so I'd like to see them created and defended right across the country. And I'd like to be a resource in that. So if you have questions, please feel free to reach out, especially if they have to do with the Fourth Amendment issue. And I do run a student clinic. And so from time to time, we will take cases or we'll write amici briefs. And so I would say that. And I would say if you are a landlord and you're not sure about this, you're not sure about taking vouchers, I would strongly encourage you to have an open conversation and talk to someone about how to make this as feasible as possible with you. to. I think the last thing that's worthy of your time and effort is to hire an attorney and try to fight this through the courts, especially because there are already so many cases and these will be decided probably well before yours. And so right now it's a good idea to comply with the laws that exist. And I am very hopeful that we'll have some clarity from the courts soon. So thank you for listening to our presentation and have a great day.
Thank you both so much for your time, and I know a lot of effort went into the presentation, so thank you for that. And I will hand it over to Carrie to close us out and echo our presenters' thanks for the audience participation. We had a huge number of attendees today, which is awesome, and really great questions coming through. So appreciate that. And Carrie, take it away.
Thanks, Catherine. Thank you, everyone, again for attending. Thank you so much to Catherine, Hazel, and Heather for your amazing presentation today. I want to give a special thank you to our sponsors of these forums, because without our sponsors, we couldn't be bringing you these forums. Third Federal Savings and Loan, City of Cleveland Heights, Cuyahoga County Land Bank, CSU Levin College of Public Affairs and Education, Enterprise Community Partners, the Legal Aid Society of Cleveland, and Legal Aid of Northeast Ohio. As Catherine mentioned, in the next few days, you'll all receive the materials from the forum today and a link to the recording, which will be on YouTube, and a survey. So we would really appreciate any feedback that you have so we can continue to provide these forum series of different topics. Stay tuned for our next virtual forum, which will be September 16th, and more information will be coming out in the next few weeks about topic and speakers. Thank you all.